here at 9 p.m. 7 years, viewers, 7 years since Nirbhaya. Finally, perhaps, we're almost there at the finishing line, and finally, there will be closure for Nirbhaya's family. For me, for women across this country, even for men across this country, who stepped out and rallied for better safety, for harsher punishment, for justice for Nirbhaya and her family, for justice to be done in any of these serious and grievous criminal cases. Because in Nirbhaya's case, all 4 convicts will be hanged to death on January 22nd in Tihar Jail. Of course, there is still a couple of legal recourses available for Nirbhaya's rapists, and this is what the process from here on will look like. The death warrant that was given a sanction today by the court will now be sent to Tihar Jail. The convicts, the rapists, can apply still for a curative petition, but experts say it's highly unlikely that will get them any relief at this point. After so many decisions, after the Supreme Court has already looked at the review pleas and nothing fresh has emerged in the case. The rapists can also apply for a mercy plea. That is the right of everybody in this country, and they can apply for this with the president. There is a 14-day gap between the death warrant that has been issued now and the execution that's going to take place on January 22nd, and that's the time they have for any of these legal recourses. But the preparations have begun, and you know it's a very tedious task. We'll get you some more details on how we really go about it, but let's say good evening to our panelists right now. Vikas Singh, former ASG, Arvind Kumar Jain, former DGP of Uttar Pradesh, Sudha Ramalingam, senior advocate with the Madras High Court, Geeta Luthra, senior advocate with the Supreme Court, and Aishwarya Bhati, senior advocate with the Supreme Court as well. And if I can actually go across to Mr. Vikas Singh first and ask him this question, Mr. Singh, you know, there are some legal recourses still left. So can we really be sure that these rapists will be hanged on January 22nd, or could the wait get longer?
Well, the legal recourse that is still open to them is for making an appeal to the President of India, seeking his pardon, because under the jail manual of the Delhi jail manual, it provides that if an appeal to the President is made, then the execution is deferred till the decision by the President. And in this case, although the prosecution has made a statement before the trial court today that there was no pending application before the President, and accordingly the death warrant has been issued, but notwithstanding that, the jail manual says that even if it has not been made, even if it is made prior to the actual hanging, and if it is submitted to the President before that, then on that basis also the execution has to be deferred. Of course, one of the options open to them is to file a curative petition, which of course is not maintainable in this case, because if the curative petition, one of the ground for maintainability of a curative petition is that you should have, the review should have been dismissed by circulation. In this case, review has not been dismissed by circulation. So if the review has been dismissed by after open hearing, so in this case, the curative will not be maintainable at all, and the same can be rejected at the very threshold. But this President's pardon option is still available with them. I believe one of the accused had applied for President's pardon, and then before the President could take a final call on his application, which had of course been rejected by the Chief Secretary. So all the recommendations had been against that pardon, and it was just pending for the President's decision. And before the President could decide, he withdrew this application. So if he were to resubmit another application and the other accused were to also submit another application, then that is the only way on which the execution could be deferred. But otherwise, I feel that this is a case where on the 22nd of January, the warrants will be executed, and these 4 convicts will be hanged to death as per the decision of the trial court, which is of one of the very ghastly crimes of this country. This whole country is waiting for this decision to be implemented, and we are also hopeful that nothing should happen in between. till it gets implemented.
Yes. Well, you know, that being now said, I want to focus on the larger conversation that we need to have tonight, taking Nirbhaya's case as an example and maybe re-looking at, you know, some parts and processes of our entire judicial system. It took 7 long years for Nirbhaya's family to get to this point. And they've run from pillar to post, from one court to the other, appeal after appeal, affidavit after affidavit, you know, simply just, you know, hearing after hearing, and so many adjournments that Asha Devi's lost the count, almost broke. She actually broke down in courts on December 18th just to get this justice. This is not a standalone case, viewers, in India. Let me put some staggering numbers in front of you that will explain how slow our judicial system works when it comes to delivering justice. Now, as per the data released by the National Judicial Data Grid, total number of pending cases in India as we speak is 3,16,33,675. I'm going to repeat this. 3,16,33,675 pending cases. This includes over 89 lakh civil cases and over 2 crore criminal cases that are still pending. The issue of increasing pendency rate actually stems out from also a problem that's been plaguing our judicial system for a really long time, and that's the sheer shortage of judges that we have. As per a 2018 report, PTR report, for every 10 lakh people in our country, there are only 19 judges available. 19. Imagine the shortage of judges we have in our country. Sometimes it's just as if the judiciary and even the government, they don't look beyond what's, you know, happening in Supreme Court. The lower courts that actually matter, that actually keep the wheels of justice going for each of these cases. That's where the problem lies. I want to refresh your memory with what transpired in Hyderabad just last month and how the nation reacted to it. On one hand, you have the Nirbhaya's case, where for 7 long years we followed the judicial route seeking justice and the rapists are yet to be hanged. On the other hand, there was a case of a brutal gang rape where the accused were then killed in an encounter just a few days later. And, you know, many in this country were celebrating it as instant justice. Obviously a reflection of the fact that we are losing faith in this judicial system. So how do we fix it? How do we ensure that it's not a 7-year-long wait for any other mother or father of a brutal crime? That's the big question, Aishwarya Bhatti.
So, Tanvi, like you mentioned, you know, judges, paucity of judges that is there, the abysmal ratio that is already there. And, you know, you've just given the judge to population ratio. What is important is that the capacity of the judges, even we don't have full strength. Not in all high courts, not in all lower courts. So the existing vacancies which have been sanctioned, those are not filled up. This is, you know, India as a developing country, we have our own set of problems. We have our own set of infrastructural issues. You know, we are always coping up, running to cope up with the resource crunch. But justice delivery system, the resource crunch is too high. And unfortunately, delays have now become such a sacrosanct part of the system. And they are almost like they're termites eating the system hollow from inside. The system has become so, it's become so fragile because of the delays that now people who want to do false cases want to come in the system to ensure that they are able to keep somebody on the tenterhooks of a pending case for decades altogether. India also has a dubious distinction of having litigation passed down the generations in wills and otherwise in hierarchy like that. So there are very, very serious problems that are there. There's enough, enough research that has happened on what is required to have a robust judicial system. Because without a robust judicial system, the democracy itself comes to a standstill. What is at stake is very, very high for a rule of law. We don't want people sorting out their disputes on the roadside. We don't. You mentioned Disha. We all know what happened in Hyderabad. All sane voices were saying in one voice that justice cannot be instant and justice cannot be revenge, which is what it seemed like. Of course, we have to wait for the conclusions, but the prima facie, that's what it appeared to be. At the same time, Nirbhaya, 7 years now, And Nirbhaya is a case that actually got fast-tracked in the entire system because Nirbhaya became a symbol of, it's not like we don't have rape cases every day. We have rape cases every hour. We also have that dubious distinction. But Nirbhaya became a symbol of the revolution, of the tsunami, of the, saying enough is enough, no more. So because of that, Nirbhaya's case got fast-tracked across the entire judicial system. But that's not the case with other Nirbhayas. That's not the case with 3 crore odd cases example that you gave of the pendency across the country. It is a very, very serious issue, and I think we all need to, the government needs to understand this more. 70 years, we haven't done enough to build a robust judiciary. Sometimes governments don't like judiciary to be extra strong because judiciary is also a spoke in the wheel. There is not enough infrastructure that is given to judiciary, but it will have to be given because without judicial infrastructure, the democracy itself is at peril.
Yes, absolutely. And but if we don't look at it now, how long will it take, Sudha Ramalingam, how long will it take to fix this problem? Not everybody will have the strength that Asha Devi had, to pursue this and to fight it at every point. We have to make it simpler in this country and faster in this country to get justice.
You're right. We'll have to make things simple. We have to also, like the former speaker said, ensure that the robust judicial system is built in where enough manpower is given, not merely the judges. There will be judges in the court, but there will not be even a computer. And if there is a computer, there will be no stenographer. And if there is a stenographer, the computer itself will not be working. Or if there is these things are there, the printer will not be there. We find that there are a lot of other systemic problems in ensuring that a court actually works effectively. The budgetary concerns are really very serious. They don't really give as much money as which is necessary. The budget allocation is very low. Having said that, there's also another side of the things. All that we are seeking for is only execution of these convicts. I think we'll have to also have a relook at the entire system. Will actually death penalties serve any purpose? Is that actually victim justice? I definitely don't feel that this is victim justice. Victim justice would also mean that you ensure that there is a real reformation in the minds of the persons who have committed the offense, and also see that the victims and the victim's family get enough rehabilitation. The Law Commission did not suggest for capital punishment at all. After Nirbhaya, the Burma Commission went into the entire atrocities committed against women, and they came out with a very comprehensive report, after which the law itself was amended. The Indian Penal Code, the Indian Evidence Act and the Criminal Procedure Code were all amended in consonance with the recommendations of Burma Commission. There also he spoke against death penalty. But now what is happening is the shrill voices of asking for death penalty has grown so much that many people had justified even extrajudicial killings in the form of encounter deaths in Hyderabad. This is not something which is real victim justice. We'll have to see that and understand that crime is also part of a social evil. So we'll have to also tackle everything from the sociological point of view, from the political point of view, and also the judiciary will have to be enhanced. So this is something which you have to think about completely positively in a holistic fashion. Don't only blame the judiciary. No. Don't keep blaming only the prosecution. As such, what happens? You don't have enough forensic evidence to be forensic labs to even produce proper evidence before the courts. The prosecution also fails. There are less number of prosecutors. The crime investigation is not divested from law and order policing. So what happens is crime investigations is at the back seat in every police department. So we'll have to think about the entire system in a very, very holistic fashion if you really want victim justice.
No, you're absolutely right. And you know, one aspect that I began with simply that aspect, which is about pendency of cases and shortage of judges. But you're right, we can't stop there. Take a look at the conviction rate, you know, when it comes to simply rape cases in our country. In 2007, it was 26.4%. In 2017, we've, you know, improved a little and reached 32.2%. That's the conviction rate in these cases. And so obviously your forensics department, your prosecution, that too has to be beefed up. Mr. Jain, do you believe that even when it comes to the basics, the starting level, that's where we falter? That the final point of justice is still at much later stage. We mostly mess it up even in just in the initial stages.
I will confine myself to the Nirbhaya case. It happened in November 2012. Seven years have passed. This is the fate of a case which has national ramifications, which is known to every person, every daughter of this country, every person of this country, and they are waiting for capital punishment to be carried out. Now, a court has fixed 22nd January. My question is, in 2014, a High Court confirmed the capital punishment. Since 2014, case is pending either in Supreme Court or in various other courts or in mercy appeals. Now, a demand has been made by the advocate of the accused that I will submit curative petition. So all this is dilatory tactics, and nation is watching all this.
Yes.
My only submission is that the way people of this country, including Nirbhaya's parents, they welcomed
Go ahead, Mr. Jain.
the Telangana encounter.
Yes.
Yeah, the Telangana encounter. It's quite obvious that people want quick justice. People want that justice should be done, and it should be done as early as possible. If so it is pending for 5 years in Supreme Court, then naturally people will point fingers at that. Why is it pending for 5 years? Why can't we have a special bench in Supreme Court to deal with such matters? Nirbhaya case has been taken up. There are dozens of other Nirbhaya cases which have not seen the light of the day.
Yes.
So this is very alarming, and we should think over it. And all the jurists of the country, advocates, judges should ponder over it as to, and our parliamentarians also, that how this process can be made simpler, so that justice is delivered.
Correct.
And the parents.
Correct. So let me take that point.
Yes.
And if I can take that point back to Mr. Vikas Singh and also say good evening to Geeta Luthra. But before I go to Geeta Luthra, Vikas Singh, you know, one of the solutions that was actually pushed a lot and talked a lot about were fast-track courts. Even a few years ago, when we started talking about slow justice and how it takes so long, and then they said for certain kinds of cases, we're going to set up these fast-track courts, and that will provide speedy justice. But now we are looking at a situation, Vikas Singh, where not too many of these courts have been set up. Wherever they have been set up, we don't have enough judges. We don't have prosecutors. Many times the hearing date comes and the public prosecutor is not available, and then another date has to be given, and then the judge is not available or somebody else isn't there. So that essentially isn't helping either, is it?
Well, according to me, this lack of judges or lack of infrastructure for the justice delivery system, according to me, itself is a very, very serious issue, and the nation has not been addressing this issue properly. If you see today, the lack of judges in the lower courts and the lack of judges in the high courts, it is only the judiciary which has to be blamed, because they are the ones who do that selection. In the lower courts, I can understand the government has some role to play. But as far as high courts are concerned, there is no role for the government. The judiciary itself has to make the recommendations well in time. So for that reason, if matter is getting delayed, that again is very, very, you know, it's again, the democracy again is at stake because of such kind of delays. As far as the fast track court system is concerned, the clamor for fast track is not only for these kind of cases, that is rape, etc., but also for these political offenders, because they are also non-suited from holding offices because of this conviction, and if they are in appeal. So they are also saying that we should also be given fast track court. So there are a lot of cases. Marriage cases are supposed to be always on fast track because there is a time limitation. The IBC code also has a fast track because that is also time bound and everything has to be done in a very short window. So the types of cases which require expeditious justice is actually now increasing, and because of which the pressure is also increasing. So I don't see why, even before a judge retires, or especially in the case of a normal retirement, why should not the person who's to take his place be appointed before that? I mean, why is the process not starting at least 6 months in advance? You never have a chief secretary's post vacant. You never have a, you know, DG of police vacant. Why do you have a judge's post vacant in any court in this country today? And that is actually really, really slowing down the entire justice delivery system.
So who do you blame for that?
And it's causing a huge delay in disposal of.
For the understanding of the common man.
I started off by saying that majorly the judiciary itself.
Yes.
Majorly the judiciary itself, because the judiciary itself has to do the process of making appointments. And the judiciary itself is, because the kind of administrative work that the judges have to do in making these appointments is over and above the work that they have to do as in dispensing justice. And now that they have taken this additional responsibility upon themselves, they should create a secretariat which should ensure that the administrative work as far as appointment process is concerned takes preemptive steps. So the process should start well before the retirement takes place, and you should ensure that there should not be a single day's delay in the office of any judge in this country, and there should be a person waiting to take charge the moment a person retires, so that because the system is such that even if a judge retires today, the trial goes on, the next judge takes the matter on from the stage from which the earlier judge had left that case. So the system has very well been drafted in the statute book, but unfortunately because of the judge not being in position many times, the dates are given and the matters. Another thing which discipline needs to be brought in is that the higher courts stay trials on petty, issues, on minor deviations in the trial process, and that also really delays the trial in a very big way. So this also discipline has to be brought in within the judiciary itself, that do not stay the trials on petty issues or petty infirmities in the trial process. Only if it's something very grave affecting the merits of the decision itself that a stay should be granted. And if that discipline is to be adhered to, then if you allow the trial to go unhindered, then whatever defects that had taken place in the trial can be corrected in appeal. In any case, appeal will be preferred. So that is these two things. If it is to be done today, I think it will go a very long way in ensuring that these fast track courts are real fast track courts, and
not just
justice.
on paper.
It should not take 7 years like it took in Nirbhaya for this kind of a case to come to its and especially in a case like this where the entire country was watching, the media was watching, and every date was being sort of reported, and still it took 7 years. So just imagine a normal trial in this country which is not being watched by the media, which is not being watched by the nation.
So then I have two questions.
Nobody bothers in those trials. Those trials go on endlessly, and in spite of.
Yes, then from taking off from what you're saying, Mr. Vikas Singh, I have two questions, and let me take the first one to Geeta Luthra. Geeta Luthra, like Vikas Singh said, this is a case that the entire country followed. This is a case that had the entire country outraging, and we repeatedly covered it. For 7 years, this case has not been forgotten by us. We've constantly tracked the updates. Asha Devi, of course, broke down. And it was heartbreaking to see her 2 weeks ago in the court crying, saying, well, everybody talks about the rights of the guilty and the accused. What about our rights? Who's listening to us? Should there be at least some kind of a time-bound system? Will that help? That the case like this shouldn't at least go on for 7 years?
so I don't think making a case time-bound is a good idea. I think in this case, if I recall correctly, because, actually it's taken a long time, is that there were some 86 prosecution witnesses. There were several defense witnesses. There were 6 accused. One, of course, became a juvenile, so it was 5 accused. So counsels for prosecution, counsel for 5 accused, doing cross-examination, examination in chief, doing a trial day to day. According to me, the trial was brilliantly well done. Now, High Court also did it with expedition. But you have to see the number of cases which are murder appeals, which are pending in Supreme Court. And though I believe the Supreme Court sat week after week, I think it was Thursdays or some special day, and it would sit beyond court time hearing the matter. Fact is that where you're talking of death penalty, you have to give the person a full right to be heard. So it's not taking the right of the victim again away if you're doing a full trial. Now, why did it take time in the Supreme Court? Supreme Court, actually, because it's the last court, and obviously I'm talking as a lawyer, and therefore it may seem as if it's being cold. I'm not being cold. We have to ensure that the every step which a person is entitled to is something which he is able to take. Now, you must remember that India is a country where we have arrears and arrears and arrears in courts. Now, murder cases are important, rape cases are important, NDPS cases are important. They take people's lives, So each criminal case has its own special ramifications. Each civil case has its own ramifications also, because for people, even the right to livelihood, the right to... So the fact is, our number of judges are few. And I've seen the way the trial works. Most of our judges work very sincerely, very long hours. You compare it with the trial in some other Western country where you'll see that the person has 10 cases. Here a judge has 60 cases. So each case has a time slot and will be heard. Here 60 cases.
But the judges also go on 2-month-long summer vacation, and the judges themselves are responsible for appointing more judges, which they are not doing. So it's very difficult to actually empathize right now.
Let me answer the question of the judges going on 2 months summer vacation.
Yes.
Let me tell you that what?
No, go ahead, please.
Let me tell you that according to me, most of our High Court and Supreme Court judges are working extremely, extremely long hours. So you can't be saying they're going for a 2-month vacation. They're not going. Everybody is... most of them have to do chamber work. They're not sitting there 10 to 5 and going away. Everybody, that most judges would be sitting every evening and poring over their files for the next day. So it's not that they are going away for such vacations.
Yeah.
Actually, we have to look at the ethos of the judges. Most will be very, very hardworking and sincere. I'm not saying, after all, they're made of the same human beings that we are all made of. So there will be people who may not be working hard. There may be people who are not pulling their weight. But ultimately, fact is, whether you're talking of the police, whether you're talking of the judiciary, the ratio with people is very low. Now, one of the aspects that I was hearing you say earlier is, say, the conviction rate is 26, 28%.
Correct.
Now, the fact and overall conviction rate is 42%. So, isn't it important that that means that a lot, it doesn't mean that the conviction rate is poor only because the courts are not doing their function.
No, I'm not saying that at all.
Hand,
Yes.
even though the courts may be
Actually,
looking,
the blame for that doesn't lie with the courts at all.
I'm not saying you are saying it. I'm just saying
yes.
Yes. So there has to be, as you said yourself just now, it has to be more forensic, more scientific method of investigation so that the conviction rate goes up and wrong people are not. So as somebody just said, it's so unfortunate that we are rejoicing over 2 people or 4 people being killed in an encounter.
Okay, no, but
you know, you don't know whether
no,
they
I
were
agree
the
with
4
you, and
wrong,
you know, I'm not going
people who were.
I'm not going into an argument or saying whether
Yeah.
judges work hard or they don't work hard. But just look at this, and there's a systemic problem which I'm actually focusing more on. In December 2018, the special fast-track court was set up, but there were no judges that had been appointed. So, you know, the case, the Nirbhaya case gets delayed. Judges who were hearing the case in Delhi court were transferred. The case got adjourned multiple times. In February 2019, the judge got transferred again. In March to April 2019, there was no judge in the fast-track court. In May 2019, a second judge sought report from Tihar Jail on, you know, authorities on what was really happening. Then in July 2019, the second judge got transferred. August to September 2019, there was no judge again present in the fast-track court for 2 months. October 2019, court served a notice to Tihar Jail, and that's how it's gone on for so long. I'm simply saying that once the decision is made, Sudha Ramalingam, once they have been convicted, once Supreme Court has upheld that conviction, once the Supreme Court has dismissed the review petition, how has it still taken us so long to get to the punishment? Death penalty or otherwise, to get to the punishment, how can it be taking us so long?
It's only the death penalty which could be prolonged. All other sort of punishment, just the person is incarcerated. That's one thing that you will have to understand. Another thing also that we forget is these people have not been released. They are not out on even bail. They are in the prison. They are undergoing that punishment, except that they have not been executed. Let's understand that the capital punishment has not been executed. Otherwise, they are under incarceration. They are undergoing their punishment. It is not as if they are lucky to be outside. They are inside the jail undergoing punishment. Let's not kindly repeat this, that they are not outside. They are suffering their punishment. Only thing is that they have not been executed. Before executing, all precautions will have to be taken care of. Understand that there have been instances of cases where a person who has been accused of and even convicted for murder, there were cases where the person alleged to have been murdered comes up alive. Instances of failure of the judicial system for a number of reasons could be there. We will have to ensure that a death sentence, which is an irreversible sentence, should not be carelessly done, performed, executed just because you are going to play to the audience. We will have to ensure that the death penalty is given and executed only as a last resort because it is irreversible. And it is also something which is not actually to be performed except in the rarest of rare cases.
I get your point, but what I'm raising is not playing to the audience, Sudha Ramalingam and Aishwarya Bhati. The points that I am raising are about non-availability of judges, non-availability of prosecutors, the authorities jail authorities not moving on time. Of course, they have the right to file a curative plea. Of course, they have the right to go ahead with a mercy plea. But what are the jail authorities waiting for? Why is the mother of Nirbhaya going and seeking for death warrants to be issued? Now, at every point, why is it the family that's fighting for justice when the system currently in our country, death penalty provisions are there? It has been pronounced and upheld by court after court. Then why are we looking at such a long process? That's the question, Aishwarya.
You're right.
Then Tanvi,
You're
Yes,
right.
I agree
But the
with you,
whole
Tanvi.
problem
Once
is that
the
you will have
death
to.
sentence has
Aishwarya,
been
go ahead.
Yes, Aishwarya Bhati, please.
Just, the point is that death sentence in India is not given lightly. Though it has been provided in the statute, the Indian Penal Code has provisions for death sentence forever, not withstanding the recent amendments that were made after Nirbhaya and also the stringent provisions in POCSO. It has been there, but the Supreme Court has made a criteria that only rarest of rare cases they will give death sentence will be affirmed. Once it is affirmed by the Supreme Court, then there should not be unnecessary delay. Review petition, curative petitions, these are not ordinary courses. These are available in extreme cases of miscarriage of justice. It's not like every review petition lies or it is maintainable. Curative petition in any case is not maintainable if the review has been heard in open court. It is in very, very strict sense that it is even, it is even available to anybody. And why should the victim's family be made to file even for getting the, the warrant, the death sentence warrant executed and issued? It is absolutely not done. The system must take its course. The problem is, Tanvi, that we have huge systemic issues. We have huge issues as a developing country. And because of these issues, we have become very, very lethargic. As a nation, as systems, we have become so lethargic that we don't even have the sensitivity to deal with such important issues. I mean, in all one breath, we want to paint it the same way. One more thing that a lot has been said by my senior colleagues here on the show with regard to the reforms that are required. The basis of our criminal jurisprudence is the investigation by the police. The police reforms in the system are so abysmal that, if the investigation is a watertight investigation with the help of technology, with the help of science, then the conviction should not take long. Why should we continue to need witnesses which corroborate the evidences? Once scientific evidence is there, and in rape cases all the more so, the accused actually leaves his mark on the scene of the crime, often on the body of the victim. So it is all there. It just needs to be highlighted. But the police needs to, fix it in investigation. And once that happens, even the appellate courts will not need to go into, shaft through the evidence for hours and hours altogether. We have to start from there. So the police reform has to start from there. Our criminal justice system, why should we still follow the adversarial system of every crime being proved beyond the shadow of reasonable doubt? Why can't we go to the European way of inquisitorial system? That, it is preponderance of probabilities. After all, our system has become alive to the victim only recently. Till 25 years back, victim did not even have a right of appeal. Now we are getting more and more sensitive to victim. I think it's more important to look at the victim's perspective. It is, victim often becomes an unknown personality because all criminal cases are state versus the accused.
Okay, quick comment.
I need nowhere to be there.
Yes.
But it is, after all, the entire criminal justice system is set up for the victim.
Well, whatever it needs to be done, discussions and debates and deliberations and changes that must be made before we actually become a country that actually start backing instant justice like encounters and start celebrating that. Final comment from Mr. Jain on the point that Aishwarya Bhati was making. Mr. Jain, should we begin with police reforms? Can that be the starting point?
If we are discussing Nirbhaya case, then I think police reforms are not the issue.
Correct.
Issue is police submitted charge sheet. Police submitted a tight charge sheet, which was capital punishment was confirmed by Supreme Court. So credit goes to the police that they have presented a foolproof case, foolproof investigation in the court, in various courts. They have succeeded. Police reforms are required. We have been clamoring for police reforms. Supreme Court has passed orders for police reforms, which states have refused to implement so far. They have defied the Supreme Court directive in Prakash Singh case. We have been insisting for independence of police. and the Supreme Court directive is also there. But states have refused, and no action has been taken against states by Supreme Court. So what can be done? 1861 Police Act is still functional. What can be said? There are so many things which we have been asking for, and I served for 37 years in UP, and we had been continuously requesting for it. So police reforms are naturally required. But as far as this case is concerned, I think more reforms are needed in the judicial system, and things have to be set right in judicial system. Otherwise, people will lose faith. The affected family members will lose faith, and they will give up the fight at High Court level or at Fast-Track Court level or Supreme Court level. I have been on several panels in which people have complained, victims' parents have complained that case has not been taken up for the last 5 years in Supreme Court. So now, what can be said about it? Yes.
Such a sorry state of affairs, and I believe that the change has to begin from police reforms, but not just stop there, then go on to the infrastructure that's provided to them, to the investigative team, to the prosecution team, ensure that the prosecution lawyers, that the lawyers actually turn up for the court hearings, and don't just simply use their time to find ways of delaying hearings and getting hearings adjourned. That's become one of the most widely used tactics by lawyers in many parts of our country today. Let's ensure there are more judges. Let's ensure there are more courts. Let's ensure that everybody doesn't have to wait for 7 years to 10 years to get justice the way Asha Devi, Nirbhaya's mother, has had to wait. And we're not done yet. We don't know. What if the mercy plea gets filed before January 22nd and more breather is given to them? If there is a verdict that has been pronounced, from there on, wheels of justice must move faster. Otherwise, we will see more examples of people celebrating instant justice. It only happens when you begin to lose faith in the current system. It's not just the judges alone, but it's a collective responsibility. It's a system that needs to be fixed, that needs to be improved. There was a massive outrage, viewers, across the country. You and I were part of that after 2012, after the Nirbhaya brutality. What has actually changed since then? A few new laws on paper? Is that what we fought for? Is that what the protests were about? Is that what we debated? Is that what we brought out? No. The change has to be on ground. The change has to be in our mindsets. The change has to be better law and order. The change has to be about the implementation, not just new laws on paper. Even today, our politicians are doing the same thing. They're bringing in new legislations. The fact is implementation and speedy justice and a fair investigation. Justice has to be delivered, not on paper, but in reality. Thank you so much for joining us on this conversation. And here's the big breaking news this evening. Bollywood superstar Deepika Padukone showed up at JNU to show solidarity with demonstrators who were protesting against the violence that occurred in the university on 5th of January. Also present right there with Deepika Padukone was former JNU Student Union President Kanhaiya Kumar. Kumar said that as a former student, he felt compelled to support the students. Let me in fact go across to Nagma, who's joining us on the phone line. Nagma, huge controversy is broken out and two very clear sides on whether or not Deepika should have showed up at that event if she was promoting a film, or if she genuinely feels for the students. Where do you stand on this point?
I think that the students across the country should not be thought of as dumb. And if they are speaking up for something, and if people, mass goons are getting into the universities, beating up students, then it's the duty of the cops and the law and order to take care of that. And if any Bollywood actor is taking, I think that Deepika also went because she has experienced something similar with Padmavat in the past. And she kind of feels, or she kind of, identifies with something like that. So maybe she went for that reason. And of course, why we live in a democracy, we are a secular country, why can't people have two different views? And what is it that if somebody has a different view, then and if somebody has a point of view to dissent, then everybody attacks that person? Why is that so happening in our country?
Do you think
I
it's
mean,
also
are we not a secular democratic country? What is there? And is the Prime Minister not standing with the students? I mean, I am quite appalled and amazed to see that people are talking about left and right. Students are students, period. And nobody has the right to go into universities, goons, marks goons, and people, and the police is not able to identify.
Fair
In
enough.
the videos that those students,
No.
those goons are walking out with rods in front of the cops, and the cops are doing nothing about it, even outside the campus.
I
And
said, okay, I
100
agree
has
with
been
you.
died
And
with the cops.
Nagma, there is absolutely no debate on whether or not questions should be asked about the inaction of the JNU administration or the Delhi police in this specific
It's not
case.
the question of JNU only. This is happening in many universities.
But my
Why
question
is
to
it
you
happening?
is this a sticky point and a tricky situation for celebrities? Because if they don't
Why
speak
is
up,
it a
they're
tricky
accused of
situation?
not speaking up.
Why is it a tricky situation for celebrities?
Yes,
Don't
let
celebrities have a
that's the
voice?
question I'm
Don't
asking.
don't
Let me
they have
finish
a
my
mind?
question.
Can't-
Yes,
yeah.
my question is exactly that, because if they don't speak up, they get trolled and abused and critiqued for not taking a stand. But if they do speak up, then they get trolled and abused and critiqued for taking a stand to promote their films, to promote their own interests. Is that a tricky situation to be in?
You know, it's very shameful that people are talking about this as promotion of a film. Maybe a person could have been in a place, but there are many people, also protesting and going in the protest and joining in the protest in Mumbai as well. So let's not, talk about that celebrities are doing something for promotion of their films. I mean, Deepika has a mind of her own, much more and above than the fact to just promote a movie. I mean, even if you see it that point as a view,
Okay.
but nobody is to go. No goons are supposed to go into universities. And
Oh, there is
teach us-
absolutely no debate about that no goons are supposed to enter any university, and if they do, they should be caught and they should be punished. Nagma, thank you so much for joining us. Completely out of time on this edition of the Urban Debate. Quickly going across to Sanjana Chauhan, who's ready with the last word. And Sanjana, what's on the menu tonight?
Tanvi, tonight we're telling two stories. One that no one else is talking about, and the other that we will keep speaking of till something is done. First, Tanvi, a Maharashtra DIG level officer was accused of molesting a minor girl. That minor girl is missing. Yes, viewers, the minor girl is missing. Unfortunately, the young victim, who is her friend, is also missing. What's worse is that the entire family had to endure threats. They had to endure several delays to even get an FIR lodged. It took 7 months to do even that. Second, Tanvi, we're looking at the infamous self-styled rape-accused godman Nityananda. Another devotee who has been missing pleaded for life in a video. It has been 24 hours, but we don't know the origin of this video. Now, this wouldn't happen had it been a common man. So why the royal long leash to this particular man? This is exactly what we're going to be looking at tonight on The Last Word.